Hello, yes, welcome to the channel. It's me, Chris Brooks. I hope everyone's well. Right, imagine a world where justice depends entirely on saying the right exact words. Not just close enough. Oh, no. One wrong syllable could see you lose your farm, your family, possibly even your freedom. That was law in its early days. A kind of bureaucratic spellcasting. The lawyers were wizards, everyone else, terrified peasants, hoping that they'd pronounced habeas corpus correctly. And into this legal Hogwarts staggered something radical. Equity. Not equality, that's politics. Equity. That's conscious. It's the moment law looked into a mirror and said, maybe I'm the baddie. So our story begins, of course, in ancient Rome. Because all good stories start in Rome, or with somebody ignoring advice in Rome. Roman law was brilliant, orderly, mathematical, and absolutely bonkers. You had to say the precise formula in court, miss a word, case dismissed. It was like Alexa but with togas. Hey, praetor, sue Marcus for stealing my goat. I'm sorry, you said capra, not capram. No goat for you. Eventually the Romans realised that a civilization of 80 million couldn't function on grammatical precision alone. So the praetor, a kind of judicial improv artist, began issuing edicts to make things fairer. He wasn't bound by the old formulas. He used reason, morality, and gut instinct. This was the birth of equity, law that could bend without breaking. England, the king's conscience. Leap 1,000 years, England, mud, monarchy, and a legal system that thought compassion was a form of witchcraft. If you couldn't find a writ to fit your problem, tough. The judge would shrug, no writ, no remedy, no case. So people began writing directly to the king. Dear sire, someone's stolen my cow and my dignity. Now, the king, busy oppressing the French or inventing new taxes on windows, couldn't answer everyone, so he handed that job to his right-hand man, the chancellor, the keeper of the king's conscience, usually a bishop, which is handy because when you're running a moral court, you want somebody who can quote both God and Blackstone. The chancellor wasn't there to tick boxes, he was there to serve justice. He'd look at a case and say, alright, the law says one thing, but what does fairness say? And that's how the Court of Chancery was born. The first time a government officially admitted that morality might be relevant. The madness of common law. To appreciate equity, you've got to appreciate how insane the law was without it. At common law, fraud, not recognised. You could lie your wig off and win. Lost your deed? Sorry mate, no paper, no property. Someone promised to sell you a horse but didn't? The law shrugged. It was like trying to do surgery with a rock. Equity came along like a pair of surgical gloves, messy, flexible, a little squeamish, but determined to clean things up. He said, if the law be rigid, I'll be fluid. If the law's blind, I'll see. If the law's a robot, I'll be the soul. That's why the Chancery became known as the Court of Conscience, not a place of loopholes, but of loftier principles. You would go there if the law had technically worked but morally failed. The legal equivalent of, technically I didn't cheat, darling. The two-court system, law and equity, walk into the bar. So now England had two systems, the common law, rigid, ritualistic, obsessed with procedure. The Chancery, poetic, improvisational, occasionally smug. They hated each other. Common lawyers called Chancery judges interfering priests. Chancellors called common law lawyers soulless bureaucrats. It was like Oxford versus Cambridge, but with wigs and contempt citations. One Lord Chancellor summed it up perfectly. The common law would give you stone when you asked for bread. Equity, by contrast, would give you sourdough and moral guidance. And despite all the squabbling, the system worked. Kind of. By the time England was sending colonists to the New World, this double helix of justice, law and equity, was firmly in place. Across the Atlantic, equity goes west. When the settlers sailed to America, they brought their Bibles, their muskets, and for some reason their entire legal system. You can kind of imagine the conversation, We're fleeing tyranny, quick, pack the bureaucracy. Each colony built on its own little version of English justice. But when North Carolina, which at that time included what is now known as Tennessee, set up courts, they included a court of Chancery. But it wasn't about wigs or Latin anymore. It was about fairness in a frontier world. Land disputes, dodgy contracts, missing deeds, the wild west of jurisprudence. By 1782, the North Carolina legislature actually declared the courts of law are not equal to the redress of all kinds of injuries. Translation: our legal system's rubbish, we need a conscience. So they turned every superior court into a court of equity as well. A kind of judicial 2-for-1 deal. Tennessee. Equity on horseback. When Tennessee broke away and became its own state, it kept the tradition. Judges rode the circuit, literally on horseback, dispensing both law and equity. Picture it, a dusty courtroom, half saloon, half sermon, where the judge in one moment might sentence a thief and in the next moment decide whether a widow keeps her farm. Equity wasn't abstract here, it was survival. And through the 1800s, Tennessee refined it. They created dedicated chancery divisions, clerks and masters, and eventually chancellors did nothing but equity. By 1834, the Tennessee Constitution made the Chancery Court a permanent fixture. It was no longer the king's conscience, it was the state's. Enter Henry R. Gibson, the man, the myth, the footnote. Now fast forward to 1907. Henry R. Gibson, Chancellor of the 2nd Chancery Division of Tennessee, publishes a treatise on suites in Chancery. This wasn't a quick bedtime read. This was a massive 13,000 plus sections, hundreds of cases, and more Latin than the Vatican Library. But Gibson wasn't just writing a textbook. He was writing a manifesto for fairness, a defence of conscience in an age of growing industrial greed. In his preface, he basically says, look, every state's got its quirks, but lawyers don't need a dozen contradictory books. They need one reliable guide that tells them how to be both efficient and decent. He wasn't romantic about equity. He saw it as practical, a system that kept human decency operational. And his work is full of those glorious Victorian sentences that go on for half a page before collapsing in exhaustion. But every line pulses with moral energy. The heart of equity. So what is equity, really? When the law is silent, equity speaks. When the law is blind, equity blinks. Looks around and says, hang on, that can't be right. Equity gave us the trust, the injunction, the receiver, the principle that fraud unravels everything. It gave women property rights before Parliament got round to it. It made sure that contracts weren't traps but promises with purpose. In short, equity made the law human. Law and equity today. By the 1870s, in England, and soon after in America, law and equity finally merged. One court, one system, with equity's principles taking the lead whenever the two disagreed. It's like a marriage where one partner insists, we'll do things my way, the kind way. And that principle, when law and equity conflict, equity will prevail. It's basically the moral software still running under every modern day court. Every time a judge says that wouldn't be fair, every time a jury uses common sense instead of common law, that's equity whispering through the centuries. The comedy of conscience. But don't think of equity as all harps and halos. No, it's messy. Judges disagree, principles collide, and occasionally fairness looks suspiciously like favouritism. One famous maxim says, he who comes into equity must come with clean hands. Which sounds noble until you remember that everybody's hands are filthy. So the Chancellor spends half of his career deciding on how dirty is too dirty. Another maxim, equity aids the vigilant, not the slothful. Translation, will help you, but not if you've been sitting on your backside for 10 years. It's justice with a stopwatch. And then there's the ultimate paradox. Equity hates rigid rules, but over time, it developed its own rigid rules about how not to be rigid. It's the yoga of the legal world. Flexible, but only in prescribed portions. Why it all still matters. You might wonder why any of this dusty old chancery stuff still matters. We've got statutes, constitutions, human rights. Surely that's enough. But whenever technology outpaces legislation, when new problems emerge faster than laws can be written, it's the spirit of equity that steps in. Artificial intelligence, data, privacy, the statutes are lagging, but equity asks the timeless question, what's fair? It's still the legal world's moral compass, sometimes wobbling, sometimes hypocritical, but always vaguely pointing towards decency. So the next time you hear somebody moaning, that law's an arse, remember, that's only half true. The law was an arse, then equity came along to teach it some compassion, self-reflection and occasionally sarcasm. So from Rome to Tennessee, from kings to clerks, the idea has survived for 2,000 years. That justice isn't about winning, it's about being right. Henry R. Gibson called his work Treatise on Suits in Chancery, but what he really wrote was a love letter to fairness. So yes, once the law had no heart, but thanks to equity and a few stubborn bishops with excellent handwriting, it grew one. Let me know what you think in the comments below. Look after yourselves and I'll speak to you all again soon. Bye for now.